Someone make it make sense.
I'll be a couple.
All right, y'all, guess who's back? It's Judge Bev. Did you guys miss her? Yeah. So I just wanted to say in advance, if there are audio issues, this has been happening with StreamYard. It's been happening to other channels as well. I apologize. I don't have any way to see it on my end. Sometimes it just sort of crackles. Other times it sort of freezes. So hopefully we'll be all good for today, but let's jump right on in. There's the sirens. Classic move.
Why would we be there? Why would we be the people in particular regulation?
Amazing. I just have to say, amazing too that Jackson is there, and he was there also for that Supreme Court. You know, we know he lives in California. Amazing that he's appearing in person for all these.
You are unmuted.
There she is. You.
22117, Commonwealth versus Karen Reed. Can I have the Commonwealth identify themselves for the record?
Good morning, Your Honor. My name is Hank Brennan. I've been appointed as a special prosecutor for the Commonwealth. Along with me is attorney Laura McLaughlin to my left.
I can't remember where I heard this. I know there were rumors floating around that Lolly was no longer on the case, and it appears that that's not. I mean, I hadn't heard anything to confirm that, but for anyone who's wondering, there he is.
Adam
So.
Lally.
Good morning, Mr. Brennan. Good morning, Mr. Lally.
Morning.
Good morning, Ms.
The
McLaughlin.
Lolly
For the
bird.
defense?
Good morning, Your Honor. Alan Jackson on behalf of
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right, so we have a series of motions here. I expect we may be here a while this morning. It makes sense to me to start with the Rule 17 motions. So the first Rule 17 motion I have is the Commonwealth's motion for records from Verizon. But I do have a question for you, Mr. Brennan. Have the third-party record holders been served in all of these Commonwealth motions pursuant to Rule 17?
Thank you, Your Honor. I understand the court might have a preference that I remove from the podium. Would you like me to answer?
It's wherever you're comfortable, as long as we can hear you.
Your Honor, I filed a series of Rule 17 motions, as I'm sure you're aware. I have not notified any of the third-party holders. I did not want to be presumptuous, seeing that I have not met the court and didn't know what the schedule would be for the Rule 17s.
Oh,
So I have filed these just to give everybody as much notice as possible. And my intention was to ask the court if we could set a date so that we could have these motions heard and hear the defendant's objections.
Oh, interesting.
Okay.
He's not ready for
All
that.
right, so I misunderstood. I thought they were on for the Rule 17 motions
Wow.
today. All right. So the record holders do need to be heard. I was wondering why I did not hear from any of the parties, other than I have the defendant's objection to Mr. Reed's records. But all right, so we'll get a date, and that date should be sooner rather than later to get notice out to all the parties.
Yes, Your Honor. I'll note that we did file 2 additional Rule 17s last night. I don't know if they've been docketed.
They have been docketed. I got them, and that's why I was wondering whether the record holders had in fact been notified. So, okay, so scheduling we'll do at the end of the hearing. Then I think what we'll start with after these Rule 17s that we'll put on pause, it's paper number 48. It's the defendant's motion for relief from the order to impound sidebar conferences. And before we begin that, is there an opposition to that from the Commonwealth?
In part.
Okay, all right. Have you spoken with Mr. Yannetti about what part that is?
I've spoken to all the attorneys numerous times. I think we're very clear what each other's position is.
Okay. All right, why don't you, all right, Mr. Yannetti, do you want to be heard by starting with the whole motion or what?
I think we can short circuit this, Your Honor. Our suggestion, I think it's a joint suggestion to the court, is that the sidebar conferences be unsealed solely for counsel at this point. Mr. Brennan's at somewhat of a handicap because unlike the defense team, he was not present at sidebar. He does not know what the conference is.
This is interesting for a number of reasons. First of all, it's surprising they've got another motion that they're both agreeing on. Both parties are agreeing on. That's very unusual. And second of all, it's interesting that the sidebars would be released to the public at some point, because that's so, I mean, I've never seen that in a criminal trial. You know, we all know the sidebars came out from Deputy Heard, and that was such a rarity. And I know that in Delphi, for example, there's been talk that the sidebars potentially could be released there as well. And now here, he's saying we request that they remain sealed except for the attorneys. But this is really surprising, especially when you've got 2 trials where there was such a lack of transparency, well, especially in Delphi, that potentially we could have the sidebars. I mean, imagine that. I don't even want to get too excited, but it sounds like someday that will be happening.
We're about. And in fairness to the Commonwealth, we've agreed that it just be released to us, and then Mr. Brennan can decide if he has a further position regarding unsealing it more than that.
Okay. All right, that makes sense. Have you spoken with Ms. King about how long it will take to get these transcripts?
My co-counsel has spoken to her only.
Which co-counsel?
Mr. Jackson.
All right. What do you have to say about that? How quickly can she get them?
She works extremely expeditiously, but she has not started them. To my understanding, there's 3 reporters who probably would split the work.
Wow, look at his beard. He's got a bigger beard going on.
And she said that she could get started as soon as there was a court order suggesting that she do so. I would imagine, given what we've gotten so far, we're talking a couple of weeks rather than
Your beard?
a month or 2. I think
Okay.
we could probably get something within a few weeks.
Okay.
2 to 3.
Oh, you know what I wonder?
Yes, just based on my experience with Ms. King.
Could be, there's like No Shave November or like November beard. I wonder if that's what he's got going on.
All right. Even though it's just for counsel, do you intend to are you asking me to unseal the sidebar conferences with the jurors?
Just for counsel, yes. I would imagine that when we get to the second stage of this, those would be in a different category from the legal rulings at sidebar unrelated to
Right.
yours.
All right. All right. Thank you.
If I could be heard briefly.
Sure.
Thank you. Regarding the non-juror information, I'm in full agreement with the defense. I think it's prudent to, if the court would consider unimpounding the documents, I can review them. If I have
Well,
any-
you can review unimpounded documents. Counsel can review impounded documents.
Then I'll begin that task. And if there's any concerns, I'll note them. If not, then I would have no concern about releasing them outside of protective order. The juror information stands in a different posture, in my perspective. I think that should remain impounded at this point. There's a pending appeal before the SJC
Yeah.
based on the request of the defense. If they are successful, would then reinvigorate the attention on those jurors. I don't see a need for juror information to be unimpounded at this point. All the other information, I don't have the same concern.
Okay. All right. Thank you. All right. The next motion. So defendant's motion for discovery of communications in the possession, custody, and control of the Commonwealth. Who's going to argue that?
I will, Your Honor. I would say at the outset that in speaking with Mr. Brennan, he had expressed a preference to be able to respond potentially in writing. So we were in agreement, subject to the court's approval, if we're going to get another date for the Rule 17 motions, to have this motion heard at that time. But I'm prepared now if the court prefers me to.
No,
argue.
I'll give you the opportunity. How much time do you need to respond in writing, Mr. Brennan?
I can respond by next week.
Okay.
Really, I'm accommodating the defense. I have a very broad perspective on Rule 14 statements. Our office has made a concerted effort to provide everything that's not only discoverable under the rule, but from my perspective, a broader perspective. I want to make sure I err on the side of caution and they get every statement they're entitled to. So we're in the process of accumulating all potential statements of witnesses which they're entitled to, and I'm going to provide them to them. I've already provided a number of statements that I frankly believe are outside Rule 14 parameters, and I'll continue to do that throughout this case.
Okay.
And so my response in writing really is to accommodate the request and then give an answer in a production of what I have. That's going to take me probably 10 days to put everything together to adequately review it and then provide a package to the defense. And so I think that if I have 10 days, I might be able to accommodate the request without any need for litigation. If they decide to pursue further effort, then I can respond.
Okay. All right. So why don't we give you, until the 27th, just after or just before the Thanksgiving break?
Appreciate that. Thank you.
Okay. All right. Does that work for you, Ms. Giannetti?
Certainly does.
All right. So let's talk about the Commonwealth's notice of scheduling, reassembly and testing of the defendant's LEXUS telematics system.
May I?
Yes.
As a matter of background, as I
Oh.
think the court is likely
I
aware,
just wanted to briefly discuss this Rule 14 that they were just talking about here. So this is a relief from prejudicial joinder. So if the joinder of offenses or defendants in an indictment and information or consolidation for trial appears to prejudice a defendant or the government, the court may order separate trials of counts, sever the defendant's trials, or provide any other relief that justice requires. And then as far as the defendant's statements go, before ruling on a defendant's motion to sever, the court may order an attorney for the government to deliver to the court for in-camera inspection, any defendant statement that the government intends to use as evidence. Well, that's normal. So relief from joinder for, it could be offenses or defendants. So we know the multiple defendants is not applicable here. But it could be offenses, right? Because we know there's the 3 separate charges. But the interesting thing here to note is that this relief from joinder can be granted if it prejudices the defendant or the state, which is, not oftentimes that you see rules in law that, in criminal law anyway, that consider the state being at a disadvantage. So it's interesting to note.
Where the Commonwealth tested information on data chips that were found in different modules that were inside the defendant's LEXUS. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were 2 different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment system, which is what was produced at trial. I hired an independent expert, and in the independent expert of the information, what he realized is that the information taken from the informatics manual and the information taken from the telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information regarding phones that were plugged into the radio, travel logs, things that are particularly relevant and material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case.
Wow.
And so after he realized his oversight on the gigabit, he filed a supplemental report.
Gigabyte, megateent. You guys remember that from W here. This is not surprising considering what we've seen with the law enforcement in this case, but also it's a big deal.
And what we learned is
we're going to get a lot of new information.
Not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader.
Oh my God.
So that way the information was not available.
Wow.
Also in the
Wow.
the infotainment system, there were actually 3 boards, not 1. Only 1
Wow.
was taken out. So there is a plethora of information on these chips that is not been downloaded that's relevant to this case. And so we provided notice to the defense that our intention is that we are going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert. So my purpose really was not to ask for the defense's permission, rather it was to notice them, this is what we were going to do. You can see from my motion, I asked to do it within 14 days. Having recently arrived at the case, it was important for me to prioritize Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they're entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date. Inevitably, we know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information from both of them. And so I've spoken to the defense. I know they've hired an expert. I know they filed a motion.
While this isn't exactly the same, doesn't this remind you guys in some ways of Murdoch? I mean, not exactly the same. This is law enforcement fucking up, but still, it's like, oh, surprise, there's like all this other information, and it's the telemetry. It's the telemetry again. Amazing.
Contesting our position. I'm not going to speak for what their position is today, but I would say 2 things. One, the defense in their motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they'd want, but we're entitled to the download. Notably, when the first download was done, the Commonwealth deferred to the defense expert to do the download. That is not my position. I don't defer that responsibility, but it was the defense expert that overlooked the proper reader that was needed for the chips that were tested. And it was the expert that overlooked the fact that there was 3 panels in the system, not 2. And our expert was astute enough to find those oversights. And that's why we now have an independent expert that is going to do this. I know experts differ.
Wow.
They're not frick-a-frack. They all have different opinions, but we've attached all of the protocol, what we intend on doing, And the reason I brought it before the court is I wanted to expedite this matter. It's important and it.
I thought we were going to have that hearing within 14 days when we first got the motion. And then Mr. McDermott told me that the defense was looking for more time, so we gave this. But we're far into the case is scheduled currently for January 27th. Sounds like you have
Judge Bev is like, yep, it's scheduled for January 27th. Of course, she's saying that. Also, just to note, Rule 17 is dealing with subpoenas, and they mentioned this at the very beginning of the trial. Remember, so far, doesn't seem to be going super well for Mr. Brennan. I mean, I'm not saying he's fucking up, but Judge Bev has it's been very clear, to me at least, that Judge Bev has expectations that she doesn't let people know of. Like, she has these expectations, but doesn't tell anyone. So I can't say that I fault him. But she came in clearly expecting to discuss Rule 17 as it applied. So because Rule 17 just deals with subpoenas, it's very broad, right? So they had the first issues that they talked about at the beginning, where she was expecting to hear the Rule 17 issues dealing with like Verizon and others, like cell phone data. And he said we need more time for those subpoenas. They're discussing Rule 17 again, but this is in reference to this telemetry that we didn't have the first trial, and she's still referencing what was it, January 27th trial date.
a lot to do that. And then Mr. McDermott told me that the defense was looking for more time, so we gave this. But we're far into the case is scheduled currently for January 27th.
Yeah, January 27th. So there's no way, especially in light. I mean, they already had plenty of reasons to want to continue this, but with all this new information that's going to be coming in, y'all know what that's like. All the data that comes out when you're dealing with cell phones and telemetry. There's no way.
Sounds like you have a lot to do before then.
No kidding.
As of right now, it's still January 27th.
And the thing is, they can't even get started on it until they've had a return on these subpoenas. And it sounds like they've not even finished issuing the subpoenas.
So all of these things, the Rule 17 motions, all of these things need to be done as soon as possible. So
I understand. And if I can just add, it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will.
Oh, not Trooper Paul, you say? Somebody else? It's interesting. So he's hiring experts. So we can already see this is a huge difference, right? Because the Commonwealth relied on their in-house, if you will, law enforcement officers, such as Trooper Paul, Trooper Green, all these other people. And in other trials, sometimes you'll see the state hiring experts to do certain things, right? We saw that in Murdoch and others. So he's hiring. So what this means to me is the state is now spending way more money on this trial than they did on the first trial. First of all, to bring this fellow in as a special prosecutor, step one. And now they're bringing in all these experts instead of using their law enforcement officers, which, they don't have to pay extra for them to come and testify. It's part of their job.
Necessarily rely upon the information that is gleaned from this
It'll
testing.
be
how long
interesting.
is this testing going to take?
As much as I hate that there's a second trial, it will be interesting to see what an accident reconstruction specialist would say in support of the state's theory, right? Because that seems like that's going to be tough. I'm really curious what that would look like.
It's a 3-day testing. It will take within a week to read it. And the sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to, but they necessarily are in a
I'll look at Holly just sitting here like a toad on a log.
flowing pattern now. And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense? Okay, okay, Mr. Jackson.
Thank you, Your Honor. I'll start by saying, in principle, we don't have an objection to the retesting of the telematics or the infotainment center, our system data. The element we have, our issue, sort of dovetails into what Mr. Brennan was suggesting about what was done the first time. He just suggested that his new expert, Mr. Shannon Burgess, was astute enough to find something that Maggie Gaffney didn't find. Well, to bring the court completely up to speed, when the initial testing was done, the Commonwealth's expert did not know how to do a chip off, physically did not know how to do it, the Joe Paul. He turned to Maggie Gaffney, our expert, who did know how to do it. She's a former MSP officer and extremely facile in this world.
And you have a different expert now. You're not using her now?
Well, we may use her, but we have an additional expert who specifically works, Mr. DeSorga, specifically works in chip-offs and chip-ons. That physical procedure of moving chips on and off of boards. It's a very technical procedure. It's very skilled.
No, this is really interesting because I'm just thinking back to the trial and in terms of with Trooper Paul and his utter disaster on the stand. But it started out with reading the telemetry data, which he seemed to not really know how to interpret. But he went on and on and on about these key cycles, and it made absolutely no sense. I've never heard of that in any other trial. But the whole point was there actually could be important information in this telemetry if you have all the data, which apparently they didn't, and if you have someone who can actually interpret it. And they didn't have the need really to analyze that so much. I feel like the ARCA dudes kind of dealt more with like the physics of the collision versus like reading. I don't think they even talked about key cycles at all. Correct me if I'm wrong, but I don't recall them even talking about the key cycles and rightfully so, because they seemed really pointless, right? It'll just be really interesting to see what happens when you've got all of the information and you've got better experts or more experts on both sides in terms of what that will look like.
Procedure. He knows how to do it. He's got it's got an extremely long resume. Having done this kind of work,
I read it.
We're bringing him up to speed in order to sort of engage it in some oversight and some observation. I don't have a principled objection to doing the retesting. What I have a problem with is that their new expert, Mr. Burgess, right at the beginning, fundamentally misunderstood the data set on the 3 chips, the 2 micron chips and the expansion chip that he looked at, didn't understand the difference between megabytes and megabits, gigabytes and gigabits, and that gave us pause. If he didn't understand that, which is at the foundation of reading the data, we're concerned that some of the data could be destroyed in whatever process he engages in. Like I said, we don't have a principled objection to the work that's going to be done. We simply want to make sure that nothing is destroyed in doing that work. It's not, and I would take a little issue with something Mr. Brennan said, it's not that the data set is missing information. We don't know that it's missing information. Berla has now updated software that we believe, I think both sides believe, could be beneficial in culling or teasing out that data set from those chips that didn't exist when Ms. Gaffney did her work previously. She put it on a reader, it was unreadable. It doesn't mean that the data is missing. It means that it's unreadable. As a matter of fact, one of the things that our expert would do and would suggest is that a process called a checksum be done. I'm gonna use some made up numbers, but let's say there's 5,123 bits or bytes on a particular chip. You can do a checksum and determine that there's 5,123 bits and bytes read now. That means down to the bit or the byte, nothing has been altered, nothing's been changed, and we know that we're dealing with the exact same data set. That checksum would be the first process in doing the additional reading. Then they can go back and use the additional Berla software to see if the data set could be read. After that's done, then my understanding is there would need to be a chip on. They'd need to resolder those
chip on
specific chips, the 2 micron
chip on
chips and the expansion chip back onto the motherboard, install the motherboard back into the truck, and then turn the truck on. That's the process that I understand. My only request is that our expert, obviously, given his expertise and his knowledge of this information, he should be there to observe. And the only caveat to that is if he makes a determination, working with Mr. Burgess or observing Mr. Burgess's work, that what's about to happen is destructive to the data on the chips, we would ask gently, and I don't think this is much of an ask, that he be allowed to interpose his objection to moving forward, contact both counsel, both parties, and if need be, present his objections either to us to resolve it or to the court for intervention. That's all. I want the work done, but I want to make sure that the data set that is on those 3 chips or additional chips that are read is never destroyed or in peril of being destroyed. That's all.
All right. Any response, Mr. Brennan?
The defense expert would not be working with Mr. Burgess. He'd be observing Mr. Burgess. The defense expert has no active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is potentially destructive testing, just as it was the first time. Fortunately, the information was not destroyed the first time, so we can access it again, but it's potentially destructive testing. The defense is not entitled to veto power during the process. That will delay things. It has no role and no purpose in it. And so inevitably, Mr. Burgess is well qualified. Mr. Burgess is competent, and he is going to test these chips and provide the information to the defense. They'll get an exact copy. The idea of checksum, there's no mystery to these words. There's a protocol that's followed where they use the old software that was ineffective, and they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. They'll provide the information that will be available to both us and the defense.
All right. So if I act on this motion quickly, because there isn't a basic objection to it being retested, when can they begin, Mr. Brennan?
Your Honor, I spoke to my expert this morning, and I asked him for a schedule when he could test. I told him I'd like it as soon as possible. We didn't finish the conversation. What he told me is December 2nd or 3rd. I told him that would be inadequate. That's too far out. I want it done before Thanksgiving because time is of the essence. And I think it really develops everything else that will happen in this case as far as other experts. So I need to resume my conversation with my expert, encourage him and insist that we make some changes in schedule. So I can't give an exact date because that conversation wasn't what I was expecting, but I don't think we can tolerate waiting that long.
Okay. All right, this one I will act on very quickly. All right, so I think that just leaves us with the motion to continue. I know it's a joint motion, but I need to hear from both sides as to why I should do that. Mr. Brennan?
Can I begin?
Yes. And the request is for an April 1st date. You're not looking to go any further than that, correct?
We are not. We are not. Your Honor, the Commonwealth has been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably.
In the interest
I
of
truly believe
justice,
it's
always a
going
good
to
argument.
Have a more efficient and effective trial. A part of my perspective is to move as quickly as I can, and that's why I've started with the Rule 17 motions. I've also tried to retain as many experts as quickly as possible. The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th.
Wow.
However, I realized when I was trying to move and facilitate the testing of these ships in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable and began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get to a position where we're turning over expert testimony, they're retaining experts to counter that testimony, and then to reciprocate in discovery, we are days, weeks, or in the midst of the trial. I want to avoid unfairness to the defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly, the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided, but it wasn't Bates numbered, which I'm accustomed to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it's been provided. And I'm doing that out of an abundance of caution, so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it, I give it to the defense. And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so
Yeah,
all it does delay the case.
no kidding, right? I mean, my God. So it sounds like, now it'll be interesting to see how this pans out. It sounds like he's got a kind of a good attitude here, you know, being fair, not playing hide the ball, giving the defense. I was looking him up, actually. He's worked as a defense attorney as well. So he's being brought in as a special prosecutor, but it looks like most of his work is actually in defense. And that actually makes sense because he misspoke a few minutes ago and said something that when I hand something over to the government, right? And then he goes, I mean, the defense. So, you know, that definitely changes things because you get a different type of respect going on there for the fairness. And it sounds like he doesn't want to waste time. You know, slim down the witness list. So we'll see what the defense says in response. But I do like that he's trying, he sounds like he's trying to be really transparent and forthcoming with the discovery and whatnot. So
Case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial. And I think it will be, importantly, more fair to the parties involved. And that's why I asked you to consider that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time with an expert of my choosing or that I would like, I appreciate I won't be able to use that expert. And so I think the joint request is something that is legitimate. I think it's well thought, and I leave it to Your Honor. Thank you.
All right. Who's going to argue this for the defendant?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion, I agree with the argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the timeframe according to the motion, is somewhat unclear at this point. Clearly, once testing is complete, disclosures are made, we would have the right to consult with our experts and potentially employ additional experts depending on what the testing.
Have you
is.
been working on that though in anticipation?
We have,
Okay.
yes. Mr. Brennan has promised to index all discovery so that both sides can be satisfied that full disclosures have been made. I know he's been working diligently on that. He needs a little bit more time to take care of that. I would remind the court that during the last trial, we were still receiving reports and some discoverable material as trial was ongoing, sometimes deep into a trial. And we're really trying to avoid that this time. It's really not fair to Ms. Reed that discovery is not complete well in advance of trial so that we can assimilate and incorporate that discovery into what would now be a retrial. And our position is, Your Honor, there's simply not enough time between now and January 27th to get all of that done and properly prepare for trial. And I would just close by saying that both sides and the court have an interest in having this matter proceed to trial expeditiously. But in our view, and I would expect in the court's view, the most important consideration here is Ms. Reed's right to a fair trial. And in light of what's outstanding and what needs to be done, we believe she would not be able to receive a fair trial at the end of January. We're essentially asking for a 2-month delay, which I believe is reasonable in light of
Yeah,
what
it
we've
really
already
is.
discussed. We do
It
not
really is reasonable.
anticipate any further continuance requests. Just
I mean,
like
it seems-
Mr. Brennan said. So we'd ask the court to
He's
allow this.
pushing it anyway.
All right. What do you anticipate we need to do for in-court hearings? You mentioned in your motion, in the joint motion, a Daubert hearing. How many dates are we talking about? We already need a new date now for Rule 14, for the Rule 17.
You know what she said? I'm thinking to myself, do you think I'm asking myself, will she rule from the bench today? And, normally she doesn't do that. However, she did say earlier in this hearing that they will discuss the scheduling at the end of the hearing. And it seems like if that's the case, she would more than likely be ruling today on this continuance because that's going to be crucial in terms of the rest of the scheduling, right? I mean, Jesus, it's November 13th. What? That's January 27th is 2 months and like 2 weeks away. That's insane. And so even asking for a two month delay, that's still fast. So yeah, just thinking of all the other trials, it's like they need to get that schedule and they need to get that locked down. So I don't think she's going to be able to really wait anymore in terms of the schedule. So it'll be interesting to see if she does rule from the bench today on that.
Questions that we have. So we need to start moving forward with all of this.
Yeah.
Is there going to be a Daubert hearing, and who is the witness that you anticipate a Daubert hearing on? I'd like to get that on our schedule now.
For anyone who's not heard of a Daubert hearing is done for an expert witness when they're going to be testifying. So we have like expert voir dire, right? That's sort of like just determine that expert's like eligibility, or if they have the training and experience and background that is enough to say yes, they're an expert at this thing, right? A Daubert hearing is different in the sense that it's pre-trial and it is more about validating a new type of science that has not yet been validated in the court of law. So for example, if someone wants to say, I'm here as an expert to testify on how effective magic wands are, just making up an example, that's not been proven in the court of law. That's a new field of science that's going to have to be validated through a Daubert hearing to see if that, so in other words, it's not about the person, it's about their field, whatever it is that they're going to be testifying about. It's about that expertise and not the person. So you're really trying to find they're trying to decide if that is legitimate or not in a Daubert hearing.
We have not yet drafted the motion, but I've given it much thought. The government at trial called an expert regarding a dog bite. Forgive me, I haven't watched all of the trial.
No, that's fine.
Oh.
All right.
That expert I did not believe
Well,
followed
that makes sense.
the proper methodology or had the expertise to make.
All right. Does the defense intend to call I've forgotten her name.
Dr. Russell.
Dr. Russell, do you intend to call her again?
I expect that she will be on the list.
All right. So why don't we set a Daubert hearing sometime in December? Does that give you enough time, Mr. Brennan?
It does, Your Honor.
Okay. So why don't we set a Daubert hearing? I know
That's
you'll
gonna
have to
be
fly
really-
her in, but why don't we get a date now
Wow.
in December for
That's
that?
going to be really interesting.
Does the court anticipate that being a different day than the date we're going to set for the Rule 17?
Rule
motion?
17, we're doing as soon as possible. We'll do before that date.
Understood.
That's going to be really interesting because, the closest thing you could compare it to is like bite mark analysis, right? And we all know that used to be used and it's no longer used. It's going to be interesting to see what they do because this was this was sort of talked about a little bit last time, and it was, she sort of had a lot of limitations as to what she could and couldn't testify to. And again, just to reiterate, there's no there's no one doubting that she's experienced and knowledgeable, right? Again, this Daubert hearing will be going more to the heart of the science of testing a dog bite, if it sounds like that's what she's going to be doing. And the challenge for the defense there will be in that, how are you going to prove that that is more reliable than human bite mark analysis? That will be the thing. But it is interesting. So they still want to bring in the whole thing about the dog because, again, that couldn't really come up a whole lot in the trial. I mean, that was something that everyone had thought about. And of course, looking at the injuries on the arm, it does look like that. But they weren't able to really support that with the expert testimony. And it sounds like they really believe, the defense really still believes that there was a dog involved, so.
So we're going to need. Maybe we can have a
So, Mr. McDermott.
May I approach Mr. Brennan for a minute?
Sure. Jim, can you pull up, Jimmy? How was, it's December 10th. I think we moved both our trials yesterday.
Would the 13th of December be available for a Daubert hearing? It's Friday.
Possibly. I think we just put something else on this morning that would be time consuming.
I could also do the 12th if Mr. Brennan's available and my co-counsel.
I was looking at the 10th, but Jim, could you look at the 13th or the 10th?
Yeah, this is the 10th.
The 10th work. The government's available on the 10th.
So I have a.
Interesting that he's saying the government and not the Commonwealth.
Okay.
Your Honor, just to be completely candid, I have nothing on the 10th. I've got to fly out on the 11th, and I've got an all-day hearing on the 11th. So I'm sorry, I'm reversing that on the 9th. I didn't fly out on the 9th. And I've got an all-day hearing on the 9th back in California, so I can't fly that day. So
Well,
I fly on the 10th.
court ends at what time?
I'm sorry, Your Honor.
You could take, a lot of people take a red eye, right? Can you come out then?
I do every time.
You can't fly out on the 9th, the evening of the 9th?
There's no way. I can't make a flight on the 9th.
Did y'all hear that?
What about
Because
the-
well, a lot of people take the red eye. Dude. The nerve to second guess him when he says he can't do it. And then she's like, well, you could take a red eye, as if he wouldn't have considered that if it were possible.
16th, it's a Monday.
We're fully booked that Monday and Tuesday.
Let's stick on the 13th. Are we still on the 13th?
Sure, if it's available.
Jim,
We just put Gaston on for that day. Yeah, we have a full competency hearing, and we also do a Gaston. Let me just look at that. Did you say the 12th?
The 12th works.
I can do the 12th.
I can do the 12th.
We'll accommodate, yes.
All right, so the Daubert hearing will be December 12th.
All right, December 12th
9
is the
o'clock.
Daubert hearing. I will try to cover that if I can. That's for the Dr. Russell.
All right.
and those motions to be filed on the 27th.
We'll get a date on that in just a minute, Jimmy.
So this, I wonder if they're nearing the end because they're already working on the scheduling, but we're going to be getting to the part about the trial because they're setting dates for December.
Do you want, when are you available for the Rule 17 motions? How about December, how about November 26th?
I have a trial that morning
Where?
in Woburn District Court. To the extent that the court would give me a protective order, I can.
Or tell them that you have a trial here, and if I need to speak to anybody, I will.
Okay, appreciate that.
Or not a trial here, but this motion hearing.
Okay.
I'd like to do it as soon as possible to get those out, get that moving.
Thank you.
So November 26th, Jim, can we do that in the morning?
November 26th.
I'm told that Mr. Jackson cannot make this one.
For the Rule 17 motions, do you need to be here in person?
If I could have 10 seconds.
So Rule 17 is the subpoenas for all that. This
During this
cell
moment,
phone.
if I can just alert the court that there's
monitoring.
one additional Rule 17 I'll have filed by Friday.
Oh, wow.
Similar to a number of.
File it and send notice immediately of the date.
Jesus Christ.
May I inquire, do I send notice on behalf of the Commonwealth or does the clerk's office send it?
Mr. Lally can inform you on the process.
He
but you can
doesn't-
Send it right out.
Again, he doesn't know because, like I said, he's really, I think he's typically a defense attorney, and it looks like he works both state and federal trials. But interesting that he's not quite sure of the steps here.
We will. Thank you.
Yes, okay.
Yeah, we'll make the 26th work.
I likely will not be here, but she
Okay.
will be right.
Are we 9 a.m.?
Why don't we do 10 a.m., Jimmy?
10 a.m. on
Get
the
all the
26th?
record holders who want to be here.
That's it. What?
Trial here with this
Uh,
motion here.
Hold on. What?
I'd like to do it as soon as possible to get those out, get that moving.
Thank you.
So November 26th, Jim, can we do that in the morning?
Yes.
I'm just double checking.
I'm told that Mr. Jackson cannot make the 26th.
For the Rule 17 motions, do you need to be here in person?
If I could have 10 seconds.
I'm shocked that she's not ruling on this continuance. So on the bottom of the screen, guys, I have
During this moment, if I could just alert the court that there is one additional Rule 17 out.
You have the date set so far?
It is similar to a number of,
File it and send notice immediately of the date.
immediately.
may I inquire, do I send notice on behalf of the Commonwealth or does the clerk's office send it?
Mr. Lally can inform you on the process.
The
but
Lally
you
bird.
send it right out.
We will. Thank you.
Yes.
Okay. Yeah, we'll make the 26th work.
Great.
I likely will not be here, but she will
Okay.
be right.
So, okay, it just abruptly ends. I'll double check and see if there's another feed that if this one cut off. Judge Bev started out saying this should be a lengthy hearing, but she was expecting to hear these Rule 17 motions, and the Commonwealth didn't understand that was her expectation, so thus they were not prepared. And so it seems like it went a lot shorter than she thought it was going to. Meanwhile, Lolly just sat there the entire time like a toad on a log, literally like a potato. Let me unshare this real quick and see if there's another feed and just make sure that because I don't understand how you can be setting these dates and also not determining if the trial's changing or not. Like, that is shocking to me. So let me just see real quick if there's anything else. Let's just see if this one's any different. Let me share this to you guys.
We do 10 a.m., Jimmy?
10 a.m. on
Get
the
all the
26th.
record holders who want to be here.
10 a.m. on the 26th.
So it sounds like she said June or January. What does she say here?
Likely will not be here, but she will
Okay.
be right.
Are we 9 a.m.?
Why don't we do 10 a.m., Jimmy?
10 a.m.
Get
on
all
the
the
Jimmy, she
record
said.
holders who want to be
Jimmy.
here.
Okay.
10 a.m. on the 26th.
All right. And all the other motions are taken under advisement.
Great.
Okay. Thank you very much.
Thank you.
That's it. So at least now we know. All the other motions are taken under advisement. Now we know for sure. I think it's hilarious how it says breaking news. Like, I would not call this breaking news. Anyway. So that's it. It's like 34 minutes, this hearing. All right. Wow. Okay. Well, here's what we've got. She's going to take it under advisement. I will keep my eyes peeled for her ruling on this continuance, but here's what we've got so far. We learned a lot. In summary, A, Lolly just sat like a toad on a log the whole time. B, we learned that there was a lot of information that didn't come in the first trial that was due to the government, or rather law enforcement, fucking up. So for example, like all this telemetry, it sounds like there's a whole host of other things that they didn't have because they didn't know how to do their jobs. And also the Commonwealth has issued subpoenas for Verizon and other things concerning like cell data and cell phone records. So it looks like there's going to be more discovery there as well. So that's huge. I mean, in these trials today, right, the vast majority of a lot of cases is built on, the cell phones and the cars. And this is one of those cases that really needed that. And it's crazy to learn that there's just so much that was missing. Additionally, big news is that the state is bringing in a bunch of experts instead of relying on law enforcement to testify in lieu of experts, right? So they're going to be bringing in an accident reconstruction specialist, not someone hired by the state or who's already salaried by the state or the Commonwealth, but they're going to hire. So they're spending a lot more money. They're going to bring in extra experts. And he also said they're going to be winnowing down that witness list, consolidating it, no extraneous witnesses. This should be a very different trial. And again, like I said earlier, even though I hate that this is happening and she should have been acquitted, we should learn a lot more and have a lot more information. And, I looks like the Commonwealth is actually going to be putting on an illegitimate type of case. So it'll be interesting to see what they do with that. Additionally, Dr. Russell, the defense wants to bring her in, and they really want to be able to get into the dog bite analysis. Hence, we have a Daubert hearing for Dr. Russell on December 12th. So you can see it at the bottom there. Here's what they have on the schedule so far. They have the November 26th will be a hearing for the Rule 17 motions. Those are Rule 17, again, that's the subpoenas related to all the aforementioned cell phone records and the telemetry in the car, all the technology stuff, right? And also, I suppose the subpoenas could also apply to any new expert witnesses that they're bringing in. But it looks like both sides are are turning that over immediately anyway, as they should. And then on December 12th, we have that Daubert hearing for Dr. Russell. That will be really interesting. So I will try to cover those. If I can't cover them live at the time, I'll cover them the next day or same day, whatever. But I will keep my eye out. She cannot wait long to rule on this continuance, because this is a big deal. They've got so much in the works right now. It's kind of crazy. And it's crazy enough to think that they would be ready for trial, even with a 2-month continuance, when they've got so much, not only new experts, but all this new data coming in. And they're going to be attempting a chip on after the chip off. It's mind blowing to me. So, so stay tuned for that when she rules. Additionally, tonight at 8 o'clock, or I think it's 9 o'clock actually, will be our next live stream for the Casey Anthony trial. And ironically enough, the theme of this one is canines, speaking of dog bites. So the vast majority of this episode is dealing with the canines and the canine handlers. And there are plenty of videos, and the dogs are really cute. They're good boys. Their names are Garrett and Bones. And they talk about, their reward for when they do a good job. And it's like a scratch on the head or a tennis ball. It's so cute. And so the vast majority of it is going to be dealing with the canines. And then after that, they are bringing in people who analyzed the, computer forensics and whatnot from the Anthony household. So, and if you have missed the previous episode and want to get caught up, I do have a video for the highlights. If you want to just have a quick, I think it's like 30 minutes, highlights of episode 10 to get up to speed. But usually we do also review that at the beginning of the upcoming episode. So tonight will be episode 11, Canines and Computers. And yeah, so this was short, and one more lolly bird for the road. How about it? One more lolly bird for the road. Matches the Boston 25's breaking news banner thing. Crazy. Okay. All right, y'all. Thanks for being here and for being a squirrel. And hopefully see you guys tonight for the Casey Anthony trial. And if not, see you guys soon on the next one.
Someone make it make sense.
Sorry, wrong thing. Wait, we are professionals here, right? Let me roll this. There we go. Even mean to do it twice. It's funny because I always forget to play that whenever I do a We Are Professionals scenario. Hi, Candace. I'm glad you're here, but we were just ending the stream. This hearing was very short, but I'm happy to see you. I was just about to try to roll the outro, and I accidentally clicked the intro. You know what's funny? That's the first time I've actually done that ever. It's the first time I've clicked the intro when I meant to click the outro. But I do hope that Candace, you will join us, and anyone else who's just tuning in will join us tonight for Casey Anthony. Again, it's going to be all about canines, so super fun, and lots of good pictures of the good boys. So, okay, with that, now I'm going to try to successfully roll the outro.